Hello, I'm Makia Metzger, the Cobb Solicitor General, and today with me is Judge Bowers. Thank you for being here, Judge.
Thank you.
This is a new podcast called Smart Justice Works, SJW is the acronym, and essentially we just wanted to talk to you about state court and bring to you basically news about state court and what we do and how we serve the citizens of Cobb County.
Well, I'm Carl Bowers. I work as a state court judge here in Cobb County. I've served on the bench since 2005 in both of the two divisions of state court. Division 2, which primarily handles traffic court matters, and then Division 1, I've been on that division since 2010. We have a civil and a criminal jurisdiction both as judges of the state court of Cobb County. Our civil jurisdiction revolves largely around medical malpractice cases, wrongful death cases, car wreck cases, and other similar related matters. We do not handle, as many people will ask, we do not handle domestic relations cases. The Superior Court handles that. On our criminal side, we handle all misdemeanor cases. The maximum penalty on a misdemeanor case is 12 months in jail. Chief amongst those misdemeanor cases, I would say, in terms of severity, are the domestic violence cases and the DUI cases.
And to stop you right there, I want to thank you for recently volunteering, giving us his free time, to be on the Victim Witness Fund board, which I head. So I want to thank you for that. I know it is your time and talent, and we very much appreciate that. That board will permit us to bring resources to our victims, and in order to disperse those funds, the board generally has to have consensus. So thank you for making it happen this year for the Cobb Solicitor General's office. Our office is tasked, as you know, some of you, with misdemeanor offenses, as opposed to felony, which would be D.A. Brody's job. We, our hope is always to ensure that we are ensuring public safety, and in so doing, we are not just making Cobb County safer for our citizens, but we are also following the law. Adhering to the law means that we obviously make recommendations. We don't sentence. The judge does, and we try to be fair, look at all cases, criminal histories, and just bring fairness to the courtroom and facilitate a fair trial if that is what someone wants to do. Because under the Constitution, that is the greatest, highest right that you have, a right to a jury trial. So we facilitate that process, and the judge generally calls balls and strikes. And
that's a good way to put it.
Right. We are at his mercy. But if it's a jury trial, obviously the jury of your peers get to hear the facts of your case, and we just ensure that the process is fair and you have a fair shot.
Yeah, the court's obligation is obviously to ensure that anyone who wishes to have a trial, whether it's a jury trial or a non-jury trial, is afforded that right. Everyone is entitled by the Constitution to a trial by jury amongst their peers, and of course we conduct jury trials frequently. As you alluded to, many people will say that the prime consideration for the court is obviously to be fair and impartial to everyone, but within that is to call the balls and the strikes. It's kind of like, I guess, being an umpire in a baseball game to some extent. And the court, is the gatekeeper for evidence, ruling on the admissibility of evidence, whether it comes in before the jury or whether it cannot come in before the jury for the jury's consideration. Obviously, as you alluded to as well, Ms. Metzger, sentencing is the court's obligation, whether it's a negotiated plea and a recommendation is put forth from your office and the lawyer for the defendant in the court decides to accept it or not, or whether it's at trial, and again, the same process may occur. The court has the ultimate say on sentencing, and that is reserved to the court to impose that sentence within the bounds of what the law allows in terms of the maximum and the minimum on any particular misdemeanor sentence.
And going back to the types of cases we hear, obviously your traffic offenses would be everything in Title 40, and your crimes against persons would be your Title 16 offenses in the Georgia Code. So that is primarily what we handle in state court. We do have ordinance cases, but that is outside of what you do, because that's not, they don't go to state court. That's magistrate court, the people's court, they call it.
Yeah.
But in state court, we see everything from your quality of life theft cases, your criminal trespass cases, obstruction, and then we have more serious offenses. Now you have, I believe, statutory rape, child molestation. Those fall under, sometimes because of the age, the misdemeanor offenses.
Yes. We'll get cruelty to children in the third degree, for instance. There's now forgery in the fourth degree. There are certain certain cases that had heretofore, until the Georgia General Assembly acted and recodified some of those offenses on the lesser side of things as misdemeanors. We do see some cases that heretofore, as you alluded to, had been heard in the Superior Court. And again, all of those misdemeanor cases, the maximum penalty is 12 months in jail. The Title 40 offenses, as you referenced, the traffic offenses, as we commonly refer to them, are oftentimes will involve a fine. Or there are serious Title 40 offenses, DUI being the most obvious example of that, driving on a suspended license, driving without insurance.
And vehicular homicide
Absolutely.
in the second degree
Absolutely.
has to be probably the one with I would say, largest ramifications, because you lose a life on the roadway due to a collision, not a felony act, but certainly very serious.
Absolutely.
With very serious ramifications for the parties involved. So that is probably one of the more serious traffic offenses that we handle.
I would agree with that. Obviously, there is a loss of life, hence the vehicular homicide charge, or the nomenclature, if you will. Yes, that would be at the very top of the list in terms of severity, because of the impact on that individual who lost their life, but obviously their family members as well. Yes, no question.
Let's talk a little bit about what we've been working on in terms of post-COVID. I know COVID kind of threw every prosecutor in the state of Georgia, well, for a loop, really. And we changed the way we do business. So I guess we have preserved some of those very smart things that we started during COVID. And I think one of them, well, what I was impressed with Cobb is Cobb courts never closed, never shut down.
That's true.
And one of the things I liked seeing was virtual court. What's your take on that?
Well, during COVID, which of course visited us in March, in Georgia, I should say, in March of 2020, if I recall correctly. I was the chief judge in state court at that time. And so basically the entirety of COVID, I served as chief judge, and that gave me the opportunity, hopefully I exercised it wisely in conjunction with all of my colleagues and other elected officials, to allow the courthouse to remain open. We did have periods of time, in all candor, when we could not, by virtue of certain orders entered by the Chief Justice of the Georgia Supreme Court, actually conduct court, but the courthouse itself never closed, meaning that those that needed to file documents, probationers that needed to appear to pay fines or pay probation fees or visit with their probation officer, things like that continued as normal. There was probably a 4 to 6 week, I can't recall now, it's been 4 years ago, period of time when we did not conduct court, but otherwise, in that interim, we that being the judges of the various courts, came up with ways that we could move cases forward once we were given the green light to do so by the Georgia Supreme Court, and that's what we did. It was in a much limited fashion than we were accustomed to, particularly in state court, because we are such a high-volume court. But we quickly pivoted, and with the use of technology that the Cobb Board of Commissioners authorized for our use, and as you alluded to, Ms. Metzger, we incorporated technology, virtual hearings, whether it's Zoom or WebEx or any other means or mechanism by which we could conduct court. We did not and do not do trials in that way because of, particularly in the criminal arena, one's right to confront his or her accuser in an open court, and that doesn't lend itself to trying a case through a virtual medium. But we did conduct many types of various hearings in a virtual fashion, including the taking of pleas and certain other types of hearings that lended itself very well to forum, and it allowed the courts, not just in Cobb but everywhere, but particularly in Cobb, it allowed us the opportunity to meet the needs of the community, meet the needs of the citizen, and move the people's business.
Some of other jurisdictions have, I guess, picked apart and found certain virtual hearings, like calendar calls, can be done virtually, or please, Jill, please, or something.
Sure.
You're not transporting all these inmates to court.
Right.
Do you think that there's any benefit to using some of those practices moving forward in terms of a savings, safety concerns, and health concerns?
Well, absolutely. COVID is not gone. I just read in the paper the other day where the scientists have identified the latest strain. It's K something or the other. I don't recall all the lettering for it, but so COVID still exists. There are other potential future illnesses that none of us may be aware today that may erupt that would suggest that we need to engage in social distancing or some other types of protocols that may not lend itself to traditional court as we understand it. So the technology exists for us to respond if and when that's necessary. I know, and this doesn't necessarily impact you and your office, but I'm the presiding judge this week in Cobb State Court, and on Monday of the presiding week, the judges have a civil motions calendar. I conduct that still virtually. It's the lawyers in general like it. It doesn't involve the presentation of evidence. It's all legal arguments, and so they can sit in their office, they can sit at their house if they want, they can sit at the beach in theory and present their argument to the court. So yeah, the technology exists. We had tried specifically, as you mentioned, calendar calls virtually when you have maybe 150 on a misdemeanor calendar, different criminal defendants, some with lawyers. That's a lot of moving parts in a virtual format. It can be done, but it really, really requires a great deal of coordination and effort on multiple offices' part, including the court, yours, the clerk's office, to allow that to come to fruition. But it can be done if and when it's appropriate. And there certainly are certain times where it's more appropriate than others, and the court has responded and will continue responding as is appropriate.
So you are certainly open to that in the future?
Yeah, we remain open. I still do, as I mentioned, I still do virtual hearings. I believe most of, if not all of my colleagues still do. I don't know off the top of my head, but many of us still do virtual hearings and are certainly open to that when it's appropriate to do so, yes.
Excellent. And I just want to pivot. We do have an excellent DUI court, is one of the, I guess, the success stories here in Cobb in terms of accountability courts. And do you anticipate any other accountability courts moving forward in Cobb State Court?
Well, Chief Judge Eric Bruton presides over the DUI court in State Court and does a phenomenal job.
I agree.
Whether I can foresee the court having future or additional specialty courts, it's hard to say. As you know, you and I, when I was chief, and those conversations still continue, had discussions about the efficacy of a mental health court. There is a mental health court in Superior Court, and that acts as, to some extent, I'm not sure the full extent to be perfectly transparent, but it does act as somewhat of an inhibitor to us having a similar court in State Court. If you know, and so many things in government funding is an issue. I think we can all agree on that. If we can get, if the funding can be made to come to fruition, certainly I think the court will consider any alternative court that helps people advance themselves and put themselves in a better position to succeed as citizens and enjoy their lives and certainly contribute to society.
Absolutely, and I do think that there is a need for it in our community. I think there's probably a need that has not been filled in State Court, and working toward that would be really very helpful.
There's no question that mental health is an increasing reality in our communities and in our work environments and everywhere where we congregate. And certainly you, as the prosecutor, and the court sees an increasing number of cases where there's an underlying offense, but there is a mental health component. And you can see that from a criminal history. You can see that from the conduct in that particular instance. You can see it from observations of that person. And mental health will continue to be the focus of many of us, and it would be something that is would be helpful for the court to be able to fully consider and decide whether it would be appropriate for us if the funding and all the actors involved in that can come on board at the same time.
And, just on a very positive note, just last week, Judge Bruton did sign an order allowing us to send cases to Superior Court. Yeah. We certainly will have challenges moving forward because
there always are,
as you know, and we don't, the buy-in and the application process, all those things are pretty tedious. So getting people to actually do that would be difficult, especially with our clientele, pro ses, low-level offenses. Moving them to a felony forum is a little bit more intimidating for those individuals. But I do think that if state court were to have something similar, we could probably interface better and be more effective.
There are certainly some individuals that could benefit from a mental health court. There are some issues, given the fact that we are limited in terms of how long we have to exercise jurisdiction over a misdemeanor. There are some issues involved in that, but there are some situations in which I very much believe that a mental health court could benefit criminal misdemeanors, no doubt.
And I am happy to hear that. Thank you.
Yeah, sure.
Judge Bowers for joining us on our very first podcast, and we hope you stay tuned and return back to Smart Justice Works.
Well, I'm honored to have been your first guest, Ms. Metzger. I appreciate the opportunity to join with you today in this, and I'm honored. Thank you very much.
Thank you. I'm Cobb Solicitor General Makia Metzger. Thank you for joining us.